Hello. If you want to file for divorce without an attorney and you share any children under 18 years old with the person you are married to, you can use this form, Complaint for Divorce with Minor Children. Usually, you file for divorce in the county where your spouse lives. In the first blank, fill in the Superior Court of, for example, Cobb County, State of Georgia. Sometimes you can file where you live if it has been less than 6 months since your spouse moved out of your marital home, or if your spouse now lives out of state. You are the plaintiff or petitioner. Your spouse is the defendant or respondent. Leave the civil action number blank until you file. The clerk will then give you a civil action number. Put in your name in the next blank. Paragraph 1. The first paragraph talks about subject matter jurisdiction, or whether the court can hear your case. For the court to be able to hear your case, you must have lived in Georgia for at least the past 6 months. If not, your spouse must have lived in Georgia for at least the past 6 months. Just check one box, A or B. Paragraph 2 talks about venue. Venue is usually in the county where your spouse lives. Check only one box. A, the defendant is a resident of, for example, Cobb County, the county where your spouse lives now. If your spouse has moved from your county within the past 6 months, you can file in that county for 6 months after you separate. In the first box, put the name of the county where he or she lives now. But in the second box, put the county where you two live together and you still live. C. If your spouse agrees that you can file in your county, you must attach a form called an acknowledgement that your spouse must sign in front of a notary. D. If your spouse lives out of state but you live in Georgia, you can still get a divorce. In this case, the court can award a divorce but may not be able to decide everything. In particular, you may not be able to get an order for child support. You should talk to an attorney before filing. E. If you do not know where your spouse is and have made diligent efforts to find them, check box E and file an affidavit of due diligence along with your complaint for divorce. Paragraph 3. Service of process means that the defendant, your spouse, usually must get a copy of the divorce papers. A. The spouse can sign a form acknowledging they got a copy of the complaint. B. Or the sheriff's office can deliver a copy of the papers to their home or work. Fill in the home and work address of your spouse. If your spouse lives out of state, you can send a copy of the complaint to the sheriff's office in the county in the other state and ask them to deliver the complaint to your spouse. Usually, the sheriff will charge you to deliver a copy of your complaint. C. If you do not know where your spouse is, you can still file for divorce. You must show that you tried to find your spouse before you can file for divorce. You can ask their family, friends, or look on social media to find your spouse. If you cannot find where your spouse is, you will have to file motion for publication and an affidavit of due diligence saying you tried to find your spouse. Paragraph 4. Fill in the date you married your spouse in A, or B if you were married by common law before January 1st, 1997. Then you can fill in the date prior to January 1st, 1997, when you started holding yourself out as married. Paragraph 5. Fill in the date you were separated from your spouse. Paragraph 6. Check the box next to paragraph 6 if you signed a settlement agreement. A settlement agreement is a document that says you and your spouse agree that you should get divorced and agree on the terms of the divorce. Both you and your spouse must sign the settlement agreement in front of a notary. Then you can file it with the complaint. See the form Settlement Agreement. Paragraph 7. Check the boxes that describe the grounds for divorce. You must choose at least one, but you can check multiple boxes if more than one applies. Check A if you and your spouse are living separately and there is no chance you will get back together. Check B if the defendant committed cruel treatment and lists the acts. Check C if the defendant committed adultery. Check D if the defendant intentionally and continually left you alone for at least a year. Check E if there are other grounds listed under OCGA 19-5-3 and explain the grounds. Paragraph 8. Enter the number of minor children you and your spouse share. Then enter the name, sex, and year of birth of the child. It is important not to put full birthdays, only year of birth for the privacy of your child or children. Paragraph 9. For each child, state the address where they live and who they live with. Then, fill in how long they have lived at this location. However, if the child or children live in a shelter for victims of family violence, do not list the address of the shelter. Instead, on the space of the address, list only the name of the shelter and the state where it is located. Do not even fill in the name of the county. Paragraph 10. Repeat this process for each address where the children have lived in the last 5 years. If you need more space, you can write that you are attaching a sheet with more information and then write the addresses on an extra sheet of paper. Make sure to attach the sheet between pages 5 and 6 prior to filing your complaint. The law requires this information for the past 5 years, which is why that time period is indicated. If your child is less than 5 years old, simply write in all the addresses where the child has lived in their lifetime. However, if the children lived in a shelter for victims of family violence, do not list the address of the shelter. Instead, on the space for the address, list only the name of the shelter and the state where it is located. Paragraph 11. Other court actions concerning the children. Checkbox A or B. Checkbox A if you have never participated in any other court case or litigation, such as filing a case, being served with court papers, testifying as a witness concerning the custody of or visitation with the children in this state or any other state, and know of no other actions concerning custody of the minor children or any other claim to custody or visitation. Checkbox B if you are aware of another case involving the minor children. For each case concerning custody or visitation with these children in this state or any other state, list the court and location, type of custody action, date that action was filed, and the status of that case, pending or closed. Paragraph 12. Others with a custody or visitation claim. Checkbox A or B. Checkbox A if you do not know of any other persons other than you and the defendant/respondent who have physical custody of the children or claim to have a right to custody or visitation of the children. Checkbox B if you do have information about someone who claims to have custody or visitation rights to the children. Write their name and the basis of their claim in the spaces provided. Paragraph 13. Child custody. Check only one box, A, B, or C. As you think about what custody arrangement you will be asking for, it will be helpful to review some of the definitions in Georgia law, which can be found in the Official Code of Georgia in Section 19-9-6. The court must order custody in the best interest of the children. Georgia law on custody states that joint legal custody means both parents have equal rights and responsibilities for major decisions concerning the child, provided, however, that the judge may designate one parent to have sole power to make certain decisions while both parents retain equal rights and responsibilities for other decisions. Joint physical custody means that physical custody is shared by the parents in such a way as to assure the child of substantially equal time in contact with both parents. Sole custody means a person has been awarded permanent custody of a child by a court order. Unless otherwise provided by court order, the person awarded sole custody of a child shall have the rights and responsibilities for major decisions concerning the child, and the non-custodial parent shall have the right to visitation or parenting time. Checkbox A if it is in the best interest of the minor child or children for someone to have sole legal and physical custody, and write that person's name. If you are asking for sole legal and physical custody, write your name on the space provided. Check box B if you want to share joint legal custody of the minor children. Then write who should have primary custody of the minor children. Check box C if you have agreed to have joint legal and physical custody. As noted above, this means the children will spend approximately equal time with both parents. Write the exhibit letter or number if there is an attached parenting plan. Paragraph 14, Parenting Time. Checkbox A if you are requesting that the defendant/respondent be awarded parenting time with the minor children and list the schedule in the following space or attach a schedule. If attaching a proposed parenting plan, write the exhibit number in the following line. If you, the plaintiff/petitioner, are asking for parenting time, list the schedule of parenting time that you are requesting below or attach a schedule. If attaching a proposed parenting plan, write the exhibit number in the following line. Paragraph 15. This section pertains to child support. Check all options that are applicable. There are specific guidelines that the court must follow when setting child support. The guidelines are found in OCGA 19-6-15. Go to the website shown on the screen and complete the child support worksheet. Pause the video if you need to. Once you have completed the worksheet, attach it to your complaint and fill in the exhibit number. This will be based on how many exhibits you have already attached. Paragraph 16, Health Insurance. Check the box if you want the other parent to maintain a policy of medical, dental, and hospitalization insurance for the benefit of the minor children. Then write how costs not covered under the insurance policy will be divided between the parents. If you are asking that the other parent provide an insurance card or other proof of insurance, check the appropriate box. Paragraph 17, Alimony. Check box A, B, or C. Check box A if you want the court to order the respondent to pay alimony for your support. Check box B if you are not asking the court to order alimony payments for your support. Check box C if this issue cannot be decided by the court in this divorce action because the court cannot get personal jurisdiction over the respondent. For example, they live out of state and have never lived in Georgia. Paragraph 18, Marital Property. Dividing property such as real estate, pensions, or investments can get very complicated. All property obtained by either party during the marriage is considered marital property, no matter whose name is on the title, except certain types of property such as gifts, inherited property, and some personal injury claims. Check A if you have already divided the property you got during your marriage and you are both satisfied with the division. Check B if you and your spouse do not have any property you got during the marriage. Check C if you have property you got during the marriage and you want the court to divide the property. Check the boxes for each type of property that applies and include a description. You can also list these on separate pages and attach them to this complaint. Check D if the court cannot divide the property. Paragraph 19. Joint or marital debts. Check only A, B, or C. Check A if you do not have joint debts. Check B if you want the court to divide the debts, including the creditor who you owe the debt to, the amount you owe, and which person should pay the debt. You can attach a sheet of paper if necessary. Check C if the court does not have jurisdiction to divide the debts. Paragraph 20. If you have been a victim of domestic violence and you are afraid the defendant/respondent will engage in further acts of violence or harassment towards you, you can ask the court for a restraining order to be included as part of your divorce. Paragraph 21. If you want the court to change your name back to what it was before you were married, check this box and write the name you want the court to give back to you. Paragraph 22. A full list of the possible grounds for divorce can be found in Georgia Domestic Relations Law under Section 19-5-3. You must check at least one option, but can choose more than one. Most divorces in Georgia are filed because the marriage is irretrievably broken. That means one party says that the marriage is broken and there is no hope of getting back together. If you check B, C, D, or E, you will need to provide proof of that ground for divorce at trial. You only need one ground, but you can put in as many as apply that you can prove at trial. Lastly, you will ask the court for relief. What do you want the court to do in this divorce case? You will see that most of this section is standardized and does not require you to make a selection. If you have any information that applies to the blank sections, fill it in. For example, if you have asked for your name to be changed, put the name you are asking for again here. You must date and sign this form, the complaint. Fill in your name, address, phone number, and email address. Remember, any information you include will be seen by the defendant/respondent. If it is not safe for the respondent to know your address or phone number, write confidential. You will take the complaint along with the other forms you have completed to the Superior Court Clerk's office in the county or judicial circuit where you are filing for divorce. You can contact the court for information on filing online. You must file the verification with this form, which swears that everything in this complaint is true. The verification is the last page of this form, and it must be signed and notarized.